Does the American Alliance for Equal Rights, what I'm thinking of anyway, as the new group, does that share are those the same funders as Students for Fair Admissions?
Pretty much. We've attracted some new funders.
It's your
Success
victory.
has 1,000 fathers. So the fact that we were able to actually do this, and it was a monumental roll of the dice to go after Harvard and go after UNC, especially with a court that had not been changed by President Trump. Remember, these lawsuits were filed in 2014. Justice Kennedy was on the court. It was a very different court. So it was considered, perhaps a bridge too far. So now that we've accomplished that, the litigation that we now have with the American Alliance for Equal Rights doesn't look so problematic.
Now, are you this is a nonprofit management question again, which and you're not a nonprofit manager or haven't, but are you going to have to be now? A lot of times increased funding means you've got to grow a bureaucracy.
Well, here's what my hope is. My hope is that we can raise enough money over the next year or two so that we can have, if not a full-time, then at least a part-time executive director. I have, between these organizations, like 8 lawsuits in various stages of litigation. And I'm in front of this computer at 4 o'clock in the morning, 4:30 in the morning, and I shut it down at 4:30 in the afternoon to go work out and then to have my first scotch. I would like to have a knowledgeable young executive director fill in for a lot of this. And I think eventually, at least over the next year, that'll happen. Other than that, we will not have bricks and mortar. We will not have the kinds of infrastructure that most organizations have. We're a one-trick pony, Michael. We file lawsuits. That's it. Some of us might remember the Peter, Paul, and Mary song, if I had a hammer, if I had a bell, I'd ring it in the morning, I'd hammer in the morning. Hey, we're the hammer. Our friends in the think tank, they're the bell. All that I have to do is raise money for lawyers, and that's a very simple endeavor.
Yeah, which means you can say in your requests of foundations that you're focused.
Right.
Admission creep does not seem to be a risk, you would either say or infer. On the other hand, having said that, you've won in the higher education context now, and you're going to look to other contexts, I assume. What are some of the cases that the American Alliance for Equal Rights is bringing in the wake of the victories?
Well, we have filed 3 over the last, I think now probably about 4 to 5 weeks. The first was to challenge a racially exclusive venture capital firm based in Atlanta that provided resources and grants and awards only to female-owned businesses that were 51% owned by African-American women. Hispanic women do not apply, Asian women do not apply, white, Native American, not here. So we have filed a lawsuit challenging what is called the Fearless Funds race-exclusive venture capital grants. That is going to hearing in the latter part of September. We filed 2 lawsuits against 2 major law firms, Perkins Coie, which is I think a 1,200 person, one of the largest law firms in the United States, and Morrison Foerster, 1,000 person law firm, offices, both firms, US, Europe, Asia. They have an internship program for first-year law students and second-year law students that is open only to racial minorities. No white applicants need apply. We have sued those. Perkins Coie has said they will vigorously fight this lawsuit. Morrison Foerster, however, has kind of waved a white flag. They have said, okay, we're going to change this. Look at our website. It's now going to be open to, all first year and second year law students. We're not going to make this racially exclusive. The courts will still have a final say in how that is adjudicated, but at least it looks like one firm is willing to admit what they have done is wrong and change it.
So that's venture capital should be looking at what it might be doing in terms of programming, as well as big law, as you've mentioned. How about big philanthropy? Just hypothetically, should there be an examination of activities going on there and funding flows and who's benefiting and who's not?
I think it's wise. Philanthropy is a unique animal in that there are requirements from the Internal Revenue Service about scope, nature, and direction of donations. And then there are elements of our civil rights laws that affect philanthropy as well. My suggestion is, not that I'm out here trying to drum up business for the American legal profession, but the landscape has changed. Private foundations should have a good long meeting, ask for a memorandum in light of the Students for Fair Admissions cases. Is there something that we need to be aware of? How we hire, how we make grants, what possibly has changed?
And then one last question, Edward, about public interest litigation more generally. What is the future? You've referenced the change to context there just now, the change to, the change to landscape, I guess. What do you see as potential avenues for either left or right public interest groups to pursue? And I there mean substantively and I guess procedurally, but what's the future of public interest litigation after this major victory, two major victories on your part?
Well, I'm gratified by this. Michael, it's the law of unintended consequences. Now that the Supreme Court has kind of opened the doctrinal running field, if you will, our friends in the public interest legal sphere seem to be energized. The Pacific Legal Foundation is going after mandatory DEI statements out in the state of California. Our friends at the Center for Individual Rights have filed, it looks like, successful litigation in Tennessee, challenging the Small Business Administration's race guidelines. The Wisconsin Institute for Law and Liberty seems to be energized. We're going to see a lot of new litigation challenging, especially in the corporate space, DEI practices, human resource practices, the way managers, for instance, a lot of corporations in the wake of the George Floyd tragedy laid out hiring quotas in which certain percentages of African Americans and underrepresented minorities must be hired by managers in corporations, or those managers' bonuses will be in jeopardy. All of that really is a complete affront to existing law. So all of these things seem to be percolating through the center-right libertarian public interest legal space. Our friends on the left are now going to be playing defense, which is a new position for them to be in. Really, for the last probably for the last 50 years, they have played offense and played it quite well. Now I think the landscape has changed for both sides.
Well, great. Thanks so much for doing this with us, Edward. I totally appreciate it.
Michael, thanks for having me.